Mr. Chairman, you may begin.
Peter, I think that was our signal.
I'm sorry.
The little voice said we may begin.
Oh, okay. Good evening, everyone. This is the Zoning Board of Appeals for December 10th. The first order of business is for us to go through the minutes. October 8th. This is me, Jeremy, and Paul. It looked okay to me.
They
Okay.
were fine by me.
Okay, so, and the next is the 12th of November, and this is me, Jeremy, and Bruce.
They looked okay to me.
You got that? Yep. You did too? Okay. And we've got IT problems. Just wait for Mr. Cook to get all set here.
Okay, we'll let you have a moment.
Take your time.
Well, we're getting a lot first.
So while we're waiting for Mr. Cook, we have a lot of correspondence on this matter. To uphold the decision by the AHRB, we have some correspondence by Mr. Batensky for Ms. Corrales and Mr. Brosey. Also to uphold, we have a letter from Mr. and Mrs. Bozard. To uphold, we have a letter from Mr. Brooks Edwards. And to uphold, we have a letter from Ms. Sandra Olson Merrill. To overrule, we have correspondence from Mr. Sharetta. And to correct the record, we have Mr. Sudak. Again, while we're working on the IT aspects of this, as we did when we had the sky exposure plane hearing, we're going to have a few rules. This is a de novo review, which means we, in effect, are the Architectural Review Board tonight. And we're not going to play he said, she said, because it doesn't matter. You know, we don't care what 3 chairmans ago of the Architectural Review Board said about anything, or an implied vote, or an implied non-vote, or any of that, or any of that kind of stuff. You know, it's just not relevant to what we're doing tonight. You know, it's the applicant's job to deal with us and to try to sell the ZBA on the architecture of 19 Livingston. They, you know, should be talking about the project, and it would probably be helpful to their cause if they addressed some of the issues that the Architectural Review Board and Mr. Batensky raised in their letters. Again, not focusing on those issues, but as you tell us about your project, you want to be addressing those things because those things are issues. You know, some are important, some are less so. But that really is up to you folks to determine. You know, why don't you hold off until
You all set now?
I think we are, yeah.
and the minutes are good without correction.
Excellent.
What's that?
Thank you, Mr. Chairman. Good evening, members of the zoning board. My name is Lino Sharetta with the law firm Wilson Elson, Moskowitz, Edelman, and Dicker. With me tonight, the applicant LDG. And I understand your comments, Mr. Chairman. I think I should, before we begin, just give a little flavor of where we started and where we are, just to give an overview of the project. I know there's some board members who I see tonight who were not part of the original time that we were here back in, I think it was May of this year. We are here tonight to appeal the decision of the Architectural Review Board. That decision basically came as a surprise to us to the extent that, if you recall, this application is now almost 2 years before the village boards. And this is an application we spent a lot of time before planning, before the trustees, before the AHRB, and this is for a 12-unit townhome project. Just by way of background, you may recall that we received approval of this project unanimously, recommendation of approval from the planning board and the trustees, both unanimous. We spent a lot of time at the AHRB discussing architecture, discussing sky exposure plane. And the reason why I scratched my head here tonight is because we were before the AHRB. We relied a lot upon what they said, and I understand it's de novo, but again, for flavor, just so you understand where we're coming from, we spent a lot of time there talking about these issues. We have Mr. Carr, who here tonight is the architect, Mr. Petretti, our engineer, but we spent a long time between planning and architectural review board going through this process, and we relied upon a lot of those statements. And some of those statements, I know I sent a video clip, also my letter I referenced them, where the members of the AHRB stated they did not have an issue. They liked the architecture. They had no problem with the architecture, and that was stated repeatedly to Mr. Carhu, to us, and we proceeded accordingly. The biggest issue, as you may recall, was the sky exposure plan. We sought a waiver from the AHRB. That was denied. We appealed to your board. Your board upheld that determination back in May of this year. So what do? We did exactly what you all told us to do. Go back, figure out a way, submit a compliant plan. We did that. And we did that, and it's not a new application. We did that with the same file number. We didn't change the footprint. We didn't change the zoning envelope. We didn't change the site plan that was approved by the planning board, or recommended by the planning board, and approved by the board of trustees. We went back, Mr. Carr went back, figured out a way to get the ridge line of the roof lowered so that we were within the sky exposure plane. We did that. We went back to the Architectural Review Board back in July of this year. There was no quorum for multiple meetings. July, August, they didn't meet. First meeting in September, there was no quorum. We finally got a quorum in September, the second meeting in September, I believe it was the 22nd, whereby it was the first time this application was heard by the AHRB, and we got a determination and a vote that they didn't like the architecture. Again, over a year before the AHRB, where they specifically stated that they had no issue with the architecture. So we're left scratching our heads. We have a 100% zoning compliant plan, approved by the boards, and the Architectural Review Board acknowledged that we met the sky exposure plane, yet they denied it on this excessive dissimilarity issue, which for over a year that we were before the AHRB was never mentioned, that the AHRB had an issue with this. As a matter of fact, they said repeatedly, we have no problem with the architecture. And that's their own words. I know there's some arguments that I took it out of context. I was there, I watched the videos again. I can send them to you, you could watch them for yourselves because it is de novo. But they said to us, we have no problem with the architecture. So that being said, we relied upon that information and proceeded on the issue of the sky exposure plan. We resolved that issue, came back, and were denied. Again, we got a decision from the AHRB, a 4-page decision, that mentions that they have an issue with the similarity when Mr. Carhu, who's here tonight, went through that exercise. I believe back in February of 2013, if you go back and look at the video of the AHRB. A little point about Mr. Petensky's letter. In that letter, the only issue that has to do with the architecture is the excessive dissimilarity. Everything else raised in that letter are issues that have been addressed. This is not an issue about view. View, and you've heard me say this back in May, you've heard me say this, you're gonna hear me say it again tonight. This is not about the View, contrary to what the neighbors and the objectors are here tonight. The View has been established. The planning board, that's their purview. They ruled upon the View. They said the View is okay. Plus, we also mitigated by providing a viewing platform on this project closer towards Cabrini. So that's in the resolution of both the planning board and the trustees. So again, it's our position tonight that, yes, we understand it's de novo, but there is no reason to go into architecture. It's been addressed, they've said it's been addressed. We have a 100% zoning compliant plan. So for that reason, we believe that the AHRB acted arbitrary, capriciously, in making its determination at the last minute, again, without any mention of these issues that were raised in that letter, that October letter, at all during the meetings.
Can I ask a question about that? The decision from October says that eventually the applicant asked to hear the chairman's comments before making your presentation, is that right?
Well, let me tell you what happened. We get to that meeting, and before I could even get up, before we even had a site plan up on the screen, the chairman, or the acting chairman at the time, proceeded to state his reasons why he was denying the application. Mind you, we had not been heard. We submitted the application, we appeared in July. The AHRB had no quorum, and part of the reason, we had asked one of the members to recuse himself because they had a blog for the past year commenting negatively on our project when that person was a sitting board member. So we'd asked that person be recused, and that person is no longer at the AHRB. But we proceeded to hear this, again, denial. I didn't even get a chance to present. And finally I said, well, before you go further, why don't we give us a chance to present our application somewhat? But it was clear from what was being read, or I know the chairman was reading something, that this was already predetermined. We were getting a denial, and that's how it appeared from that meeting.
So did you didn't discuss the architecture there?
We discussed the architecture.
At that meeting?
At that meeting, they voted to deny us. We presented briefly. The architecture was discussed throughout the course. Again, briefly, they had no comments on architecture. They liked the architecture.
I've heard you say that, I read it, but I'm asking, at that meeting, did you engage on the architecture?
No, I said to them, you already commented, and I played them a video, okay, with several meetings, and I stated to them specifically, how do you say now that you have a problem with architecture when you said to our face, and we took those statements and relied upon them in our plans, that you had no problem with architecture? It's somewhat disingenuous, unfair to our standpoint. We're there for we're over a year. We're there before that board.
I have a simple question though. When they articulated their concerns about architecture at that meeting, I'm just asking, did you engage on it? Did you try to persuade them?
We engaged, and we said that my comment was specifically that we went through this exercise, and there's no need to go through it now. Your issue is sky exposure plan, and that's what we were here to fix.
But didn't two things happen between when you first presented and September of 2014? Didn't the architecture change at least modestly in order to modify the sky exposure issue? And didn't the composition of the board change?
The composition, two things. The architecture is the same. We didn't change the facade. We didn't change. The only thing we did was lower, and again, Mr. Carwin was portrayed to speak to this, we lowered the ridge line so we met and did not breach the sky exposure plan. That's all we did. Everything else remained the same. Nothing changed.
Could I just ask, I believe everything that you've said up to this point is not addressing the one and only issue that's before us today. As Chairman Hoffman said, the standard is de novo review, which means we are not here to look at whether the procedure followed by the ARHB was arbitrary or capricious or not, whether you were led to believe one thing and relied on that. None of that would be a basis for reversal. We're here to consider this de novo, which means we have to decide whether there is evidence supporting an affirmance of their decision, or whether there's evidence on which were we sitting in their shoes, would also deny the application.
Let's,
You haven't addressed why the ultimate conclusion, which is the only thing that's being appealed, the only thing that's before us to review, why, I think you would better serve your interest by addressing why you think the findings with regard to the architecture are wrong, not why the way they were
I'll tell you
reached
why
was
they're
unfair.
wrong. There's no basis in that decision for that determination. They talk about an appraisal that was submitted, and I use that term loosely. The appraiser never showed up to testify at the AHRB. We weren't presented with copies of the appraisal, nor was the appraisal actually discussed at the AHR meeting. Yet they refer to it in their decision, don't attach it to their decision, and yet we aren't given an opportunity to refute those findings in the appraisal. They vote on,
But remember, the question is, if you have something to refute it with, here we are.
right, but there's a due process component to that. You have to be presented with that opportunity. We never got the appraisal. They just bring it up on it, but wait, understand me. You can't expect us to appear before a meeting, and then all of a sudden, they're talking about appraisals. We never received appraisals.
But
So
you're not hearing us because you knew about the appraisal before today's meeting, and we're exercising de novo review. So if you have a problem with the appraisal, tell us what it is, not that
Right,
you didn't
address
get
the
to-
issues.
Because it's our position, again, that, I understand it's de novo, but it doesn't take away our position that this was arbitrary. It was last minute, it was something, we knew they were gonna deny it all the time. So
So here's- sir,
let me just
sir.
finish.
No, actually,
They wanted to find a reason to deny it, they did. We shouldn't have to come here and prove our case with
You know,
respect to
what-
things that were not in the
do you have some
record.
legal authority for that being put to the technical review we're supposed to perform?
You're saying de novo review.
We're doing the same thing that happened with this application all along. And that is, you know, you don't want to get in an argument with a board where you want to win them over. You know,
Understood.
things were argumentative at the planning board, they were extremely argumentative at the architecture review board, and it won't help you.
But
You
it
know,
won't help us either.
telling your case will help us.
We're
because
telling
we
you
can-
what our
we
case
can-
is.
We can only make a decision based on what you tell us.
We're telling you, you can't have us, we can't comment on things that are not submitted in the record. You're asking us to comment on appraisals.
Are you
They
saying
want-
you still haven't seen them?
We finally got them, but they weren't attached to the decision. We
When
had
did
to
you,
get the village.
when did you get them?
We got them about, within about a week or two after the determination.
Okay, so you've
Yeah.
had time, you've
We've had,
had
but-
right to say anything you want about them, right?
This is true, we can say tonight what I feel about those appraisals.
That's what we're asking, because you have a choice. You can engage with us about the architecture, or you cannot. If you don't want to, just tell us that, and we'll make our decision based on the record we have. If you have something to say it. I think that's what we're telling you.
And we'll,
Let me just, for clarity, for the public is to this, for clarity. We sit de novo, which means we have the power, just as the AHRB, to approve or not approve the design based upon objective design criteria, just as they did. Our code has certain standards as to design criteria. It says that if something is excessively similar or dissimilar, it can be denied, because we as a village have aesthetic concerns that we are entitled to enforce. The issues go to architecture and massing. What I think this board and my colleagues are talking about is we would like to hear from you as the applicant as to why you think the architecture and the massing of this project is either not excessively dissimilar or not excessively similar. That's what we're here to hear from them, as well as anybody opposing it. Not about views or anything. We want to hear about excessive similarity and dissimilarity. So if you could address that, we'd appreciate it.
I won't address it, we'll have Mr. Carver, and we anticipated this, so that's why I brought Mr. Carver here this evening, so.
Just pull this?
No, never did.
All right, finally. Good evening. I'm John Carter, architect for the project. A little bit caught off guard because regardless of this being de novo, there is a history, and we developed this project without the benefit of hearing these findings. So there's no way we could further address the findings in the denial. But what I can do is go through the process of how we got to where we are. And before I even started the project, I took a survey of the streetscape, which I'm very familiar with anyway, having been the architect for Livingston Ridge. I also read all the codes relative to design, including the residential design guidelines, and tried to incorporate all those elements as well as possible into our design. As far as the actual massing, as far as the overall massing of the buildings, front building is here, rear building is here. Front building is actually substantially smaller than Livingston Ridge. And we tried to create a viewport here and a viewport there and leave gaps on both sides so that there was a separation from the neighbors.
Could you talk about specific dimensions on those buildings? Because from from Google Earth, that strikes me as not accurate.
Do you have plans? Are you talking, excuse me, are you talking about the Livingston Ridge or my proposal?
No, Livingston Ridge, your building is 140 feet, and I'm trying to find what Livingston Ridge looked like, but
Well,
somewhere.
I have the plans for Livingston Ridge, and those units are considerably deeper than these proposed units. So
I was thinking lengthwise,
In terms of length?
which is the view to the street, that passersby see.
it's longer than each of the individual buildings by about 1 unit. But there's enough room there to split them in two. This site doesn't have enough frontage to allow you to get into the site and also split the front building in two.
But as a result of that, isn't the bulking greater than at Livingston Ridge?
Well, took other measures to try to mitigate the fact that it was one building. This is a survey of some of the houses on the street that we thought represented the historical character of the area best. And if you look at these and the massing of our facades, they're very identical. I could overlay my building over one of these.
Aren't those buildings about 40 feet wide?
No, I think they're substantially wider than 40 feet. They may be 40 feet deep. I don't have a survey of these, but just visually, that's substantially more than 40 feet.
Well, that's how it kind of measured out in Google Earth. I'm not sure about that specific one, but certainly this one on the left right here, I think was in the high 30s or at 40 at the maximum.
This one may be. These are the Second Empire style. The previous ones were the Queen Anne, which are both.
That's 39.
That's 39.
Livingston Ridge is 77.
And
you're at 140.
Very, very large house here. This is Livingston Ridge, which is a mirror image of itself. It's two identical buildings but mirrored. And this is a view down the street. All right, so what I did was try to pick up on the character of those existing homes by separating this building into three distinct areas, each with a projecting gable, projecting porches, separated roofs that allow views through there and separate the buildings from each other. We also stepped them vertically relative to each other and horizontally relative to each other. So that if we hadn't taken those panes, there would be a continuous ridge here. And the facade would be flat. But we didn't do that. So we felt that the spaces between these porches and on the ends mimicked spaces between the houses on the rest of the street. Again, it's hard to tell in a two-dimensional picture. Oops.
Can you say what you meant? What you meant when you said there wasn't enough room or space to divide it into, like Livingston Ridge, or you said something like that? I don't know if that's exactly what you said.
I'm sorry, sir, I forgot your question.
I just was trying to understand, I think you said something along the lines of the land or the area wasn't big enough to split it into two the way Livingston Ridge is split.
Well, there's sky exposure plan on each of the side properties. We need to get a driveway in because we want to get the cars off the street. That requires at least 30 feet of width. And we could have chosen to do individual units, but the space between them would have been very small. Basically useless in terms of any kind of visual aisle between there. If you walk down the street, many of the spaces between existing homes are not very wide, and they contain fences and landscaping, all sorts of things you can see maybe 20 feet deep. So there isn't this sense of vast vistas anywhere, except maybe at the far end of the street as you go down the street.
But I still don't understand, I mean, it was possible at Livingston Ridge to have some separation between the buildings. Why is that impossible here?
There was a much wider site.
Well,
So we were able to get a driveway.
you're saying if you wanted to have this many units, it wasn't possible. Obviously, you could have had fewer
Well,
units.
the topography kind of forces you into putting the driveway at the north end of the property. That's the low end of the property. So in order to get onto the site with cars, and especially with a fire truck, you have to start at the lowest level. So that wipes out that whole area in terms of doing anything else. We couldn't spread the units and for instance, have a driveway go between units. We couldn't develop the length to get down there because you're starting higher. And we can't go further back because we would be pushing the units over the steep cliff. We want to stay off the steep cliff and obey all the other zoning requirements, which we did, setbacks, side yards, the sky exposure plane, which was never an issue on the front building. It was an issue on one corner of the rear building, which is not even visible from the street. The same approach we took on the front building with the porches, we did on the rear building by having separated garages with gaps between them, creating discrete elements that mimic the homes on the street.
You know, could I just ask you to focus on one particular thing? In the decision by the ARHB, under the section where they're discussing excessive dissimilarity, they made a finding that the neighborhood context is one of singular freestanding residential structures that allow for space, light, air, and views between adjacent buildings. Do you disagree with that?
Well, I think that Livingston Ridge has two attached townhouse buildings that are a significant portion of the site that were approved, built, and won a national award. So I don't agree with that. What I agree with is that we took the basic massing of the existing homes, we took the elements, the gable ends, the roof pitches, front covered porches, posts, tall vertical windows, which is an element of this style of architecture. And basically use the same elements that we're using in other homes on the street to create the continuity between them and a harmony. So, you know, in terms of dissimilarity, I hardly disagree. I mean, they're so similar to other homes on the street that if you put photographs of the finished product next to each other, you would think they were twins.
I have to say, I don't see that. Can you give me an example of anything else that's similar to this?
You have to understand that each one of these will read separately in reality. You'll see, as you're coming down the street, you're gonna see 3 separate roofs and 3 separate gables. Each one of those will read separately, like on this streetscape, you're seeing the front gables. You're not seeing what's in here, and you never will driving by in a car. The only way you can see it is if you walked here and stood between the buildings and tried to look. But you will get a very similar feel with these 3 peaks as you're getting here.
Well, but I understand that you've mimicked or replicated architectural elements of the older buildings. It's not that I think is the dissimilarity. It's the packaging of those elements into one continuous facade that makes it dissimilar. I don't think that's similar with the adjacent properties.
Well, attached housing is a permitted use in the zone.
But it is
But
dissimilar
that's a
to what
different issue.
exists. That's what the comment
Well,
was.
our attempt was to be as similar as possible within an attached building, and I think we succeeded in doing that.
it just doesn't read, if you're looking at it, it doesn't read the same. The elements, the kit of parts that you use is similar, but the way it reads is different.
I think if you saw the building finished or a scale model, you would feel differently.
Looking at your
Because of
rendering,
projection.
that's what I'm seeing.
It is very hard to convey in 2 dimensions. All I can say is it would have, this project would have the same degree of refinement and sophistication as Livingston Ridge.
Which mass is different, because there's space between the buildings.
Each one of those buildings on Livingston Ridge is equivalent to this one building. They're almost the same size.
But, you know, I mean, you're talking about the experience of someone passing by, and I'm not sure why we should only be concerned about people driving by and not people walking by, but leaving that aside, it seems to me the experience is very different than the experience of passing Livingston Ridge, because these are all, it's one continuous wall of repetitive architecture.
But, you know, you're talking now about the basic concept of the project, which was approved by the planning board. The site plan was approved. And
But
the
the
Board of
architectural
Trustees
was
approved
left to
it.
the architectural review board.
Not the massing.
But
So the
massing,
site- the
massing-
site plan-
massing is
the
part of
site
part
plan
of,
was
part of the
approved.
criteria that the ARHB applies and that we have to apply. It's not,
Well,
there's
how
not,
an
there's nothing
applicant-
that says that's no longer the purview of the ARHB because you got a favorable ruling from a different board.
All right, I'm an engineer, not an architect, but I kind of understand the village, okay, and I also understand this site. And I know that you're asking this gentleman questions about the massing, and I just wanted to point something out. And I did this with the planning board when I went out there. You have our vacant space right now, which is 19 Livingston. You have 29 Livingston, and you have 33 Livingston Avenue. And so 29, okay, is now under renovation, all right? And 33 has been built, okay? And you basically have lots that are 50 feet, 60 feet wide. You basically have 10-foot offsets. I think 33 has a sideline that's even narrower, okay? So what you have is you have a space, okay, between 33 and 29. Now, one of the goals that I had here was to look at this objectively and say to myself, how can I get the widest view to the river, okay, and still build the units? So if you went from the river, if you go from 19, you're looking out to the river, you got 19, us, 29, 33. You've got the 10-foot offset between the physical structure of 29, which is under construction. You got 10 feet to the property line. Then you got another 35 feet. So you wound up, okay, with a 45-foot expanse, okay, which that's what you want. Now you can see the river. You know, looking back at Livingston Ridge, okay, you have driveway, 3 units, I believe, 10-foot space maybe, another 3 units, another driveway. All of that is cluttered with vegetation. You can't see the river there. So my objective here was to push the units to the left and give you the 45-foot expanse of the river. And that was the reason we did that. Now, I agree with the architect's architecture. They liked it, okay? The planning board has people on the board that are architects, and they viewed this, okay, pretty much the same way I did, okay? We went out there. I had them all out there. I said, look, guys, from this building line, 29, all the way over here, 45 feet over, you're gonna see the river. So I just wanted to tell you that. That was the objective of the plan.
Just note one of their comments in one of the comments in the opinion was on the sloping stuff. Explain to them the fire hydrant, the fire engine, the reason why it's built the way it is.
Well, listen, I think I said enough. You got 45 feet, and I mean, the planning board was out there with me, and they really appreciated the fact that you could ask them, you don't have to believe me, okay? But that was the objective, to, you know, these little 10-foot spaces, if you broke these units up and you had this little 10-foot space, you don't gain anything, okay? And they saw that. And there was a couple of gentlemen on the planning board that appreciated that. You had this 45-foot width. Now you're gonna see the river. Now you're not gonna cluster that up with vegetation. So, that's it.
Yeah, your comment kind of puts me at a loss, because basically you're talking about changing a site plan at this point, if you want to change this into discrete buildings, which means we're starting over again. I mean, you can't go from one board to another and have to start from scratch at every board. You have to be able to rely on something. If that comment had come up during the planning process, we would have a different project now. And I would have worked within those guidelines. As it is, I worked within what we had to work with and what was approved.
Well, but when you do a project, you don't do a project for the planning board. You do a project for all boards. And, you know, the architect, you know, once you go through the planning board, you know you do have to go to the architecture review board. And, you know, while the planning board, you know, is concerned with footprints and mass and whatnot, you know, this board, for excessive dissimilarity or inappropriateness in relation to any other structure existing or for which a permit has been issued, or to any other structure, blah, 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 with the following features: massing, cubical content, gross floor area, height or bulk of the building, height of the roof, or other significant features. You know, I don't think anyone is quarreling, you know, with the height of the roof. You know, in a sense, you know, you are mimicking the other houses on the street. It's just that the massing is not. Again, Google Earth might be a little bit off, but I measured Livingston Ridge at 77 feet. You know, most of the other buildings are high 30s to low 40s wide. You know, I mean, that's, you know, and that's why I think the AHRB and why we are having a problem with the massing.
Architects articulate facades by breaking them up visually with different elements. And that's what we created here, is three distinct facades. Yes, they're linked, but they're distinct.
I'm not sure I see how they're, to me, they seem more similar than distinct. But maybe, so could you explain that to me? Could you show me what makes them each distinct?
The massing of the building,
I mean, you're talking about like there's three similar designs in a row, is what I see. What's the distinction between
the way I read this, and most architects would, is that you have three distinct elements to this building. They read separately, and in 3 dimensions, they will do much more so.
Well, I'm seeing something that it looks like, if you looked at it in a mirror, it would look exactly the same. I mean,
Well, are you arguing dissimilarity or similarity?
You just told me that the visual impression of this is like three distinct structures, and I don't see that.
Well, the similarity of this project to the street is what I explained, because we copied the basic massing and the forms of existing buildings, which makes them similar to the rest of the street.
But this particular, what we're looking at on the screen right now, has a feature that nothing else on the street has, which is a pattern that repeats itself 3 times.
There's this unit. Oh, I'm sorry. This unit has a tower that the other ones don't have.
That doesn't, the one on the far right has a similar tower.
Yes, it has a tower, but it's the mirror image of the other one. Same as Livingston Ridge, the buildings were mirror images of each other. and this has a front entry that the others don't have. Other than that, you have to maintain a consistency in a building, consistency of design. You can't arbitrarily throw in elements that aren't going to harmonize with the rest of the elements. That's why it looks this way.
Basically, you're saying the three separate ridge lines create a separation between the buildings.
Yes.
And looking at it, I understand what you're saying, but I don't necessarily agree that it's accomplishing what you're seeking. It doesn't create a separation between the buildings per se, like you do when you're looking at three separate homes. It reads as one home with separate ridge lines.
Well, there's also a horizontal separation and a vertical separation. So they will appear to be discrete elements.
Yeah, and I understand your point about if we were looking at it three-dimensionally, the curve of the street might give you a little bit more sense of that proportionality, but the massing still reads as a unified structure. That's all we're saying about similarity and dissimilarity, and how it differs or similar to what currently exists on that particular block.
You said that you could show us how this fits, this fits in with the character of the neighborhood by showing us other houses. Can you hold up a picture of another house and show us what you're talking about?
There's one. This one is very similar.
Would you,
This one is very
could
similar.
you, I understand you're trying to manipulate the computer, but when you do
Sorry.
that, you're blocking the screen.
This house is very similar in massing. You have a central element with a wraparound porch. This one has the front gable, 2 stories, with the same type of hip roof.
But stay with that for a second,
Yeah.
and look at the differences. Roof type is different. There is that space between the buildings which creates a different scale. The height lines are different. You know, you're trying to, your design replicates some of the features, but the overall effect is different.
There's a story separation between these sites also, which we can't replicate on a level streetscape.
Mhm.
This, I think, is a very good example of Queen Anne architecture. And that went a long way towards determining the aesthetic that we came up with. This one's also very similar. Here's a gap between buildings, I'm sorry. Here's the gap between buildings on Livingston Ridge. It's 10 feet, it's fenced, and it's planted.
I'd like to try and make some sense out of what's being said about the individual houses. And again, I'm going to repeat myself. I've lived here for a long time, and I'm very familiar with that street. And what you have is basically lots that are somewhere between 50 and 60 feet wide. And you have some older houses down towards High Street. A couple of houses now are being renovated. One was knocked down. Okay, and what you have, okay, is basically older houses that don't have very good parking. And what happens with that is you get, and some of them are rental units, and we hope one day it'll disappear, but they may not disappear. Okay, and you have all these vans and everybody parking, okay? And it's a very unsightly type of a situation. So I had explained to you before that I opened this up with a 45-foot breadth, okay? And they, on 29 Livingston Avenue, they're gonna have the parking down in the back, which we hope to expand because there may be an opportunity to do that once we get this project approved to kind of enhance the parking at 29, okay? So if you look at the other houses, you're gonna see lots of cars parked between them because there's no garages, okay? Or the cars would be sitting in there. So the whole function of Livingston Ridge was to get a driveway down the back and get the cars in. So you have a choice here, okay? A bunch of little houses with everybody parking, okay, and all that clutter. Or you have a 45-foot expanse, okay, to see the river between 29, okay, and 19 our project, and the cars around the back. So there's sensibility to what was designed here, okay? And I understand your questions about massing. But you know what? 3 houses with vans parked between it, that's not good massing.
Have other questions?
Could you show us what the structures are within 200 feet of your lots? And then show them also on the site plan.
This is Cabrini and the parking lot. So, and part of the proposal for this property is to clean up, remove this wall and replace it with a see-through fence and clean up the brush and trim the trees to open up a view vista through here. Single-family home here, single-family home.
What's within 200 feet of your lot?
I would say it includes Livingston Ridge and these 2 properties in Cabrini.
And across the street, what's within?
Right.
That's the 200-foot limit?
Okay, so you have 1, 2, 3, 4, 5.
Do you have street views?
7 single-family homes that are on elevated sites, so they're higher than the street.
Are all the shots that you showed us before from the street views within the 200-foot limit?
I believe there are a couple here, further down, but I don't know for certain. Along here is a wide variety of styles, from 60s ranches to ranches over garages, and they're kind of eclectic, let's say. It's very hard to get a handle on what I wanted to do is try to maintain the historical character of the site, the more traditional feel, and a more sophisticated feel. As far as not responding to the hillside, we pushed this driveway as far as we could, still allowing a fire truck to come through. This building sits on the streetscape, parking is 1 story below, identical to the concept of Livingston Ridge. These units start at that lower level, so this entire building is 12 feet lower than the front building. It'd be basically invisible to the street, except as you're coming north along the street. You won't see it at all coming south. And it's pushed down as far as it possibly can go without going over the cliff and allowing the cars to actually reach there. Otherwise, we'd have to park on the street.
Are you saying that in response to a finding by the ARHB?
Isn't there a finding that not responding to the hillside?
one of the findings was that they didn't take into consideration the hillside.
I would say that we did it as far as you could feasibly do it, practically speaking. Yeah, Paul's saying that this was the limit of Rudy's parking lot. We pulled off of it because there was some erosion over here and some crumbling of the retaining wall. So we kept off the unstable slopes. Another finding? I believe the residential design guidelines I've addressed. That was an entire basis for the design, is following those guidelines. This is page 9 out of the residential design guidelines. This is a Queen Anne home, which is one of the accepted styles. If you look at this and you look at this, it's virtually identical. And these are printed as examples of good design. Oops, can't read it. This is also from the residential design book. You can't read it, but it says larger buildings should have more complex roofs with lower secondary roof types. Roofs should read as a cohesive total and should be consistent with the architectural style of the building. In other words, a main pitched roof could be combined with secondary roof types, but roof must read cohesively and relate to the architectural style of the structure. That was one of our goals, and I think we met. This one says, large roof expanses should incorporate dormers, turrets, skylights, and other features that help reduce the scale of the pitched roofs. We have all those elements, but there are no skylights. Face of dormers should be minimal in height and made up mostly of window area. Our dormers were designed directly to meet that requirement. The following roofing materials are encouraged. Asphalt shingles, that's also something we use. This is about facades. This says the design of the main facade should reflect the scale of nearby development through modulation of vertical and horizontal elements, which we did, such as changes in predominant wall plane, use of projections, which we did, alignment of cornices, and so forth. We purposely misaligned them so that they would appear to be separate. Design treatment of sides and rear of proposed buildings should be substantially consistent in appearance and quality of materials to treatment given to the main street frontage. We have exactly the same elements and materials on all four sides of the building. Let's point out, this is an example of what they meant. It's It's a single building. The only differentiation here, this is a mirror image. There's a difference in the entry porticos. That's an example of what they were looking for when they wrote these guidelines. And this refers to having windows that are more vertical and horizontal. This is regarding building massing, page 25. Building footprint should be modulated to achieve varied building shape and mass. Varied footprint shapes create opportunities to provide more complex building shapes with the addition of small-scale wings or additions to the main building. We've done that by providing projecting dormers, porches, projecting garages. There's dormers on the roof. Massing should be...
Just so I'm clear and everybody's clear, what you're addressing now are design guidelines that weren't part of the ARHB's concerns in their decision. Is that right?
I made the same presentation before the board 2 years ago, showing them the same examples.
No, I understand. I just want to be clear. You know, when you are addressing specific concerns that have been raised, as opposed to things as to which there may not be an issue.
There's a statement that we didn't follow the design guidelines, and
But they were specific about the ways in which they felt that it wasn't consistent with the design guidelines. I don't think, it just seems a little bit apples and oranges to be talking about you followed guideline A, B, C, and D when you know, if someone raises an issue about that, I think it would make sense for you to respond to it, but I think it would be more helpful to us if you would address the specific things that
I'm trying to give you the background.
So it's de novo, so you're telling us it's de novo review, so we're going through this application as we were the AHRB. So we're doing exactly what you were asking of us. We are going through this de novo. This is the presentation that we submitted at the AHRB, and we're doing it again because that is what you've asked us to do. So again, I'm not sure I follow where you're going with this, because these issues, again, we were presented at the board. There were comments that they liked it, so we didn't spend too much time. We went through a couple meetings with this issue, got over it, and then again, focused on the one issue that we spent a lot of time on, the sky exposure plan. But we are going through this de novo, and that's what we're doing right now, so that's why.
The comment then is, architecture is more than simply checking a list of boxes, saying, I've done this, I've done that, I've done that. I mean, and that's essentially what you're just doing. I check off this box, I check off that box, I check off that box. What we're looking at here is more holistic. And holistically, when I put those boxes you've checked together, is what you've created similar or dissimilar. That's a matter of opinion. I may say similar, you may say dissimilar, or vice versa. But it's not looking at, I've checked this box, I've checked that box. We have a neighborhood that looks like a series of single-family homes developed with different types of facades, with space between them primarily. Oh, it's evolved organically over 200 years. You're coming in and saying, I'm gonna take elements of each of these pieces, and I'm gonna put them together to create a structure. And we're saying maybe that structure is too large when you put it all together, given the context. Or maybe it's, you know, that's the kinds of things we're talking about in looking at the application.
Understood, but we have to proceed also on objective guidelines as well. There are guidelines we have to follow, there are zoning codes we have to follow, so.
No denying that.
If there are issues, I mean, we're talking about a very subjective issue here. So we have guidelines and codes and laws that we have to follow, which brings me to my point, what I said, we came here, it's a zoning compliant project now. So now we're getting into issues that, again, they are subjective in nature. We're presenting exactly what we presented, so I think for your own purpose and ours, we need to go through this exercise, because again, that's what I understand that you all want to see.
And I am going through these individual elements, but I'm not saying we're checking boxes and throwing them together. There's an assimilation process that any good architect takes that captures the flavor of a neighborhood and tries to replicate or do something that is going to be a harmonious part of that neighborhood when you're done.
And I think that you said that well. That's exactly what this is about. Did the project succeed in doing that? I think you stated the objective correctly. Or did the project not succeed in doing that correctly?
Well, the project is the sum of its parts. And if I had ignored these guidelines, you would be telling me that I ignored the guidelines.
Proceed with your presentation.
And I'm not trying to be argumentative,
That's okay.
it's just a catch-22. And I don't mean to bore you with this, but I'm trying to make the point that it's a thoughtful design. It wasn't just arbitrarily thrown together.
Well, I don't think anyone is saying that it was arbitrarily thrown together. I for one just have, the hurdle that I keep having a difficulty with, is the massing, cubicle content, gross floor area, part of the excessive dissimilarity. And when I went on Google Earth and tried to measure things, the houses whose architecture I think you've captured well, whether it's too repetitive or not, I don't think I feel qualified to say. But those houses, are about 40 by 40, and this is 140, and I'm having difficulty with that, because that to me seems excessively dissimilar.
Well, it's actually 3 23-foot units that happen to be joined.
Well, but it does, the code
But
doesn't
it's
say,
not
the
what
code
we
doesn't
mean by
say,
massing. I mean,
the code doesn't say apparent massing, it says massing. And
It is massing. When you articulate the facade and the roof of a building, you're playing with the massing. Those are the tricks that architects use to articulate and refine a design. And after, the next step beyond this would be to refine this even further. I mean, we're talking about schematic drawings that were done 2 years ago. We got our site plan approval, we assume that we have a footprint that we can work within, and that's what we worked in. What you're talking about is changing the site plan.
well, but presumably your site plan took into account dealing with the AHRB and the constraints that they put on you.
Well, they had no issues with these, they had none of these issues. Well, they did now, after the fact. We proceeded for 2 years based on a certain progression in the project of approvals, and a lack of criticism, actually, a lot of good comments about the architecture, and then the findings come out saying that it's totally wrong. I mean, it doesn't make sense.
There's certainly a lot to be said, perhaps on both sides, for flaws in the process. And we could talk about that for a long time, but I think for better or for worse, depending on which side of this you're on, what's before us is to make this decision about excessive dissimilarity, excessive similarity, and whether you were treated fairly or not fairly, whether you were given fair notice or not given fair notice by the AHRB. Those are all, in my view, significant issues, but they don't actually impact what we have to do tonight. And that's just the reality. That's what de novo review means. That's what the code means when it says that we're essentially sitting as the Architectural Historical Review Board. So that's what we're doing. And so we're the audience. We're the ones who, under the law, are given the decision, given this appeal, to make these determinations, subjective as they may be, of excessive similarity, dissimilarity, and the other items that are relevant. So, and I think you're, in my view, you're doing an excellent job of addressing those for the most part. Occasionally we're getting off track, but for the most part, you're addressing those issues, and everybody will, on the board, will form their own opinion, but it just is, it's, again, whether it's fortunate or unfortunate, this is the way the system is set up. And, were I devising the system, I would have a lot of thoughts about how this might be done differently and how it could be more clear, more fair, better notice. And I'm not faulting the other boards. I'm just saying this process certainly hasn't worked in a way that I think anyone would call ideal from any perspective, but that's just not, it's neither here nor there at this point. We have a decision to make, we have criteria to apply, so to the extent you're focusing on that, which I think for the most part you are, that's very helpful to all of us, I think. But the rest of it is, it's not, it's just not relevant at this point. So, I would just suggest, if you have further comments about the specific issues that we have to decide, I think we can hear those for a few more minutes, and then we sort of need to, I think, move on. And there are people who want to be heard on the other side, and then we have to make a decision.
I'd just like to say that I'm pretty confident that if I was making this presentation to a group of my colleagues, they would understand what I'm doing and recognize to what degree I was successful at doing it. And am I 100% successful? No. I mean, no project is going to be 100% successful. But within the realm of reality and feasibility, I think we did a very good job. That's it for me, unless you have more questions.
Thank you.
Thank you.
I just want to understand, because I'm just listening to the comments, is this board's position that what happened in the record of proceedings that led up to why we are here is not being considered by the zoning board? And I'm talking about the planning board approval, that there's no deference given to any of those approvals now that I'm before this board? Is that, and I just want to know if I'm hearing that, because I know I hear de novo, I hear we don't care about what happened before.
De novo means, show us a standard that says we're supposed to give deference to other boards. We have specific criteria in the code that we're to apply. The fact that another board did something is not in any of those criteria. So, yes, you're hearing that our decision is based on the merits of this application without regard to the history of, another board doing something one way or the other.
This board, when it sits de novo, will hear the application as to the AHUB standards. So we're gonna look at the design guidelines, those standards de novo. We certainly are gonna consider the site, the conditions of the site plan approval that you had, and how you fit within it. But right now, today, we're not going back and relooking at what they did, but obviously we will consider the context in which the project is being built. So we're not ignoring the record before the AHRB, we're not ignoring the record before the other boards, we're considering all of that in its context. But still before us is the standard of review, so if you would continue on those points, beyond what you've already presented, if there's anything else you want to present.
Well, it's interesting, you say de novo, but when you look at the architectural review board and the code, they talk about who's on that board, okay, what you have to possess to be in that board.
Who talks about this? I'm not sure who you're addressing.
I'm addressing your board. I mean, there are criteria, I'm just saying, you're saying that we don't look at, well, you said that you do take into account what happened before. Is that what I'm hearing?
We take into account the entire record, but we sit here
Well,
and get to make
but
our own determination.
We've asked the
about-
question, is there somewhere in the code that you can point us to that suggests that we defer to decisions made by the other boards? We're not aware
I
of
believe
that.
that New York state law has that criteria with respect, especially with respect to planning board determinations.
Can you be more specific? That doesn't help
I mean,
us.
that's something that we need to put in a submission to address that, we will.
Well, you
If
have a
you like
submission
to-
that cites the wrong standard of review, right? You talk about arbitrary and capricious. We came in saying our understanding is that it's de novo, and now you're throwing out something else. I mean, it makes it a little hard for us to do our jobs. You know, most legal submissions on an appeal start with, here is the applicable standard of review. I think we're pretty clear on what we think it is, and you're not giving us any, you didn't give us, and I'm not hearing you give us now, any specific citation to the contrary. So you sort of leave us in a difficult position.
And that we can do, but all I'm saying to you is that we went through this exercise tonight de novo, Mr. Carper made his presentation, but also for my record that I need to make, there was a situation that we had an issue at the AHRB where a decision was rendered that was, again, unsupported by any discussion or deliberation. So that's the difficulty that we're having. We had, Mr. Carver said it himself, you proceed under a certain mode. I mean, you say, okay, this is what we do. We're doing this within these parameters. We're told that things are fine, they're okay, and we proceed accordingly. So that's the difficulty that we're having. Again, I understand what de novo means, but at the same time, we have to make our record as well to say that there was a termination made, yet we had no idea how they got to that because there was no deliberation. There was no discussion of these issues.
And all we're saying is now convince us instead of trying to convince them. So is there anything else you want to add?
We'll hear the public comment and reserve a right to respond.
Is there someone else that would like to be heard? And please give your name for the record.
Of course. Good evening, Mr. Chairman, members of the board. My name is Keith Batensky. I'm the attorney for Annalisa Corrales and John Brosi, who are here with us tonight. Ms. Corrales resides at 12 Livingston Avenue, which is directly across the street from the proposed project, and Mr. Brosi resides at 152 Broadway, which is across the street and just slightly further than Ms. Corrales' residence, but also with a direct view of this property. I just want to applaud the board for taking a look at the objective criteria in the code and comparing the proposed project to the structures that are within 200 feet of the project. And I think the numbers themselves are very telling. So you have two buildings, each of which is approximately 140 feet long by approximately 70 feet deep by approximately 45 feet tall. By my math, each building in terms of cubic square feet comes to about 441,000 square feet, give or take. So if you add, you multiply that by 2 because there are two buildings, you get to 882,000 cubic square feet. Now, if you look at the other single-family residences in the neighborhood, you have, they're approximately 40 feet long by approximately 40 feet wide by approximately 45 feet tall. That gets you to about 72,000 cubic square feet. So it looks like you can...
Livingston Ridge?
Well, a lot of those buildings are more than 200 feet away from this property, so I would submit that they're not relevant. The ones that are not nearly as long, and the proposed buildings at this particular site are also on a 1.29 acre property that's substantially steep slopes, as opposed to Livingston Ridge, which I think is a much larger property, so you have to really look at it in context. But by my count, you can take, the proposed project is roughly speaking about 12 times larger in terms of cubic square feet than the small single-family homes that are directly across the street. And those are really the homes that are going to be directly impacted here, right? So Livingston Ridge is to the north and has a view of the Hudson River. But one of the things that the board respectfully needs to take into account is the effect on property value, which is a code criteria. And two appraisals were submitted, one for Ms. Corrales' residence and one for Mr. Brosi's residence. Those appraisals are undisputed, and they show that there's going to be significant adverse impact on Ms. Corrales.
Could I ask you a question now?
Yes.
This is, the appraisal is what versus what?
The appraisal looks at properties with a view of the Hudson River versus properties with an obstructed view of the Hudson River, which is what this would be. Again, when you look at the proposed layout of this development, you have a 140-foot wall along Livingston Avenue. It's parallel to and within 20 feet of
I guess I can understand the obstructed river view, but a totally unobstructed river view is probably an unrealistic expectation, of comparison, is it not? I mean, is this supposed to be a Rudy's empty lot forever?
What the code seems to say is that the new structures need to be consistent with the neighborhood. And if you look at the structures in the neighborhood, they're broken up. Even Livingston Ridge has breaks.
No, but
has physical
I'm asking
breaks.
about what the appraisal was based on.
The appraisal looks at similar sales, comparable sales in the neighborhood, and analyzes properties with a view versus without a view.
I don't think that's the chairman's question. The chairman's question is, what are the considerations that the appraisal have? If the appraisal is assuming that there's gonna be an open view across the way, that seems to be a faulty appraisal, because something will be built there.
Well, again, it's not, the analysis is not necessarily whether or not something's gonna be built, but it's how it's gonna look, and whether or not there's gonna be some view preservation. And here, because of the way that the proposed buildings are laid out, we would submit that it virtually eliminates the view from the homes across the street. And I have photographs of the homes across the street, which were not included in the prior presentation, and it's very telling, because they're relatively small structures, and they're broken up. And I don't have a PowerPoint presentation, but I can show you essentially what they look like. So this is what the AHRB was using. These are directly across the street from 19 Livingston. So there's a very stark contrast between the proposed development and the homes that are directly across the street, and those are the homes that are going to be.
And those are 30, 35 feet wide.
Roughly speaking, yes. They're small, single-family homes that are broken up with physical gaps. In terms of the excessive similarity, the two buildings that are proposed are nearly identical in the sense that they're both 6-unit buildings, 3 units stacked over 3 units, and they're both roughly, the similar dimensions, and they're both roughly parallel to Livingston Avenue. So, when you look at the AHRB decision, they very methodically go through those code criteria and point to evidence in the record. And they found that the preponderance of evidence, which is the standard in the code, yielded that result. I think that the testimony earlier from the architect that the width of the property didn't allow for the buildings to be broken up is very telling, because it's essentially that in this case, the applicant was trying to fit a square peg in a round hole, because the property just didn't support this bulky structure without having to compromise the scalability and the ability to break up the buildings so that it would be similar to the homes directly across the street. So now it just looks like an enormous structure. So in summation, I don't want to belabor the point. The criteria in the code are very clear. The HRB took a hard look at those criteria and evidence in the record and found that the project was excessively similar and to itself and dissimilar to the surrounding neighborhood. We would ask that this board affirm that finding.
Do you have a view, if one were to conclude that this this proposed structure was, or is, or would be excessively dissimilar to the sort of single homes that we're talking about, but wouldn't be excessively dissimilar when compared to 19 Livingston Ridge, right? And if they're both of those, the set of single homes and 19 Livingston Ridge are in the 200-foot zone that we're charged with considering, how do you think we ought to think about that and resolve that?
Well, two things. I think it's important to note that the code changed since Livingston Ridge was constructed. So multifamily housing complexes are no longer permitted in the MDR1 zoning district. That's significant. And the reason why the village board enacted that is because it was an attempt at phasing out those massive types of development which are out of character with the neighborhood. So this goes contrary to that. It's contrary to the vision plan, which advocated for the preservation of the old Rudy's historic structure, or if it was redeveloped, a community use. So it's contrary to the vision plan, it's contrary to the zoning. And I think the board really has to take into account the reality of the situation, which is that The properties that are gonna be most impacted by this are the properties across the street. This property, 19 Livingston Avenue, stands between the properties across the street and the Hudson River. And maintaining, taking that into account is part of the intent of the zoning code as a whole, and I would submit the HRB criteria specifically. So in terms of which should gain more, which should have more weight, I think that the houses across the street should have more weight in the analysis.
I'm not sure if you're done or anybody else has questions. Let me go back to this concept of excessive dissimilarity or inappropriateness. How is this excessive?
Well, it's excessive when compared to the size of the structures that are within 200 feet. So if you look at the single-family homes across the street, they're approximately 12 times smaller than the proposed structures at 19 Livingston.
So the objection is to the massing.
Well, that's one of. It's the massing, it's also the layout. For example, if it had been the same massing, but the buildings were perpendicular to Livingston Avenue instead of parallel to Livingston Avenue, then that's a totally different ballgame. I'm not saying it wouldn't still be objectionable, but it might be less objection. It's a combination of everything. It's how the buildings were laid out, how big they are in terms of massing, and how tall they are in terms of height. You have to remember that there's an entire parking level on the ground floor. So these are 3.5-story buildings, right? You have parking, residential, and then a peaked roof on top of that. So they're really enormous structures. The elevation, most of the elevation drawings that were shown tonight were from Livingston Avenue. But if you look at it from the west, from the Hudson River, these are massive, massive structures. And I would submit excessively dissimilar to many of the other homes in the neighborhood.
Do you have an architect who's rendered such an opinion or any other objective criteria on which we could base such a finding?
I think if you look at the photographs in the appraisal reports of the other homes, it's not something respectfully that you necessarily need an architect's opinion on. It's pretty obvious that these other single-family homes are substantially smaller than this structure.
You're saying to us that the mass is larger, the design criteria is out of context with the neighbors. Where's the objective criteria for us to rely on? Where's the professional opinion for us to rely on to come to that conclusion?
Good question.
Or are you just saying we should base it on our own opinion?
No, I'm not saying that. You have 3 design professionals that were appointed by the village board, namely an architectural historic review board, that are especially qualified individuals who review these types of applications on a daily, if not weekly or monthly basis. And they've been doing this for years. And those individuals took a hard look at the evidence in the record. They looked at the proposed buildings, they looked at the surrounding buildings, and they found, in a very well-reasoned 4-page decision, that the application was excessively dissimilar. So I think that really should inform this board's decision.
Well, do you have a citation to a provision of the relevant law that suggests we should defer to their findings?
Well, you're sitting in as an appellate board, right? So you're looking at the HRB's decision and you're deciding, granted, you can hear the evidence de novo, but you're deciding whether or not that decision should be affirmed or reversed. So I think as part of that analysis, it's important to keep in mind what the role of the HRB is. And I'm not saying that this board should defer necessarily entirely to that board, but it should be taken into account that these are design professionals who are appointed for a very specific reason and are qualified to do their jobs, and they did it well in this case.
I'm just ask my fellow board members, in your experience, has there been a situation where, on a question of excessive dissimilarity or similarity, sort of experts were brought in other than parties that were interested, or an objective expert? I think you raise a good question. It seems to me, like, who's gonna decide whether it's excessively dissimilar, and it is a very subjective thing, but I'm not sure there's anyone other than us that is charged with doing that.
In past cases on this point, we heard just from the applicants and whoever the professionals were that they presented. I don't think we necessarily heard from an independent expert. We do have the power as a board to obtain one if we wanted to. I'm not suggesting it, but it is something that we could consider, or we could rely upon some of the efforts.
The only other time thing I can remember is that there's been at least one occasion where a member of the AHRB came to our meeting and discussed the reason for the AHRB's decision. And that sort of served as the technical counter, or the providing us with the better understanding of how the AHRB made their decision.
The case law does instruct us that we must rely on objective criteria, and absent that, we go down troubled waters.
I just wanna say, just so, there's no suggestion that we followed, that suggestion. I don't think we should defer to any other boards, including the AHRB. I think we're sitting as an independent board, and so, we're gonna make the best decision we can based on everything that's before us. By definition, this is an appeal, and if the body being appealed got some sort of extra consideration, I don't think that would be fair either. So I think we will make our decision without deference to any other body's actions.
Yeah, I think, we may struggle a little bit with the visuals, in terms of, I guess I'll speak for myself. I struggle a little bit with the saying that this is excessively dissimilar or excessively similar, excuse me. When you see three buildings together, are they excessive? Well, they're very similar. Is that excessive? I'm not sure. I may have to make that decision. I'm not sure that that's the linchpin. I struggle a lot more with overcoming the mass and cubicle content and gross square floor area issues. Because those, while we don't have mathematical numbers on every building, I went to Google Earth and I measured buildings out, and we know approximately what they are, and that's a problem for me.
So under the excessive dissimilarity.
Yes, right.
Analysis.
The size
Those
to me
aspects of
That is
dissimilarity.
objective.
Right, exactly.
Yeah, I think the architecture picks up well on some of the Queen Anne buildings that we saw. I struggle in well, I don't struggle. The context, though, is a lot different on those buildings because of the airiness feel, for lack of a better term, which we don't have in this building. And I think the Architecture Review Board, was pointing us in that direction, and I do struggle with that.
If I could just add one quick point on the excessive similarity, I think the analysis is really not unit to unit, but building to building on the excessive similarity. So if you compare the front building to the rear building, because of the similar dimensions in architecture, I think it's excessively similar. I think that's what the HRB was getting at. And then on the excessive dissimilarity, I think if you just look at that Google Earth analysis and do the footprint analysis alone without even getting into cubicle content, it is a very stark difference when you look at the two homes immediately to the north at 29 and 33 Livingston, and the homes that I showed you before in those photographs that are directly across the street. They're much, much smaller in terms of footprint than the proposal at 19 Livingston.
How do you think we should deal with the fact that this is a different zone, is it not?
It's the MDR1 zone. I'm not sure what you mean by a different zone. Different than what?
Is the house next door in the same zone?
Well, the Cabrini nursing home is not. That's in an institutional zoning district,
Yeah.
but the homes across the street and 19 Livingston are all in the NPR1 zone.
So we are comparing apples to apples in terms of what's there and what's allowed.
Yes.
We'll return to a question which the applicant raised. So we have a site plan approval for sites that are going to be clustered. They've dealt with the architecture within a clustered development. Let's assume for this discussion that it's correct and appropriate to have a clustered development there. Don't we then have to deal with the massing, with the assumption that it is supposed to be clustered, and therefore they're going to be together, and they're following a planning board guidelines that direct them that it's okay to have a clustered development? So aren't you just kind of doing an end run, as I think the applicant is suggesting, around the planning board approval?
Well, two things. First, I don't think that the planning board approval is really binding on the AHRB. The planning board acted in its capacity as a recommending advisory board only, and it issued its recommendations subject to the AHRB's determination. And the village board wisely did the same thing when it finally granted site plan approval. So when you look at the site plan...
But the planning board did authorize the footprint.
Yeah, but footprint is different than architecture and in terms of breaking up buildings. When you look at the site plan criteria, what is the village board looking at? They're looking at drainage. They're looking at environmental impact. They're looking at certain things that don't include necessarily things like massing and bulk that are within the purview of the AHRB. So that's why the village board, when it granted its approval, made it subject to the AHRB's review. And I should point out that the Village of Dobbs Ferry Code encourages joint meetings between boards. So if there was any inkling that there might be an issue here with massing, the applicant was within its rights to request joint meetings. And maybe that was done. That was before my time. Maybe that was done, but from what I understand, there were serious concerns with the bulk of the project from day one, and the sky exposure plane was a symptom of that problem, and the applicant decided to proceed at its own peril and go ahead and get site plan approval, and then only to find out that it couldn't get the sky exposure plane. By the way, the denial of the AHRB application caused the applicant to modify the site plan in order to meet the sky exposure plane, and I would submit that the applicant needs to go back now to the planning board and village board.
How did they modify the site plan? They just modified the structure.
I believe the structures might have been shifted in order to meet the sky exposure plan. I could be wrong. The plans were not easy to read, and you know, I'm certainly not an architect, but if that were the case, then...
I think there was no change. We can check later.
Well, at any rate, I think the short answer to your question is that I think the AHRB is certainly within its rights to take a fresh look at those criteria such as massing, because that is the criteria in the code. So it plays a different role than the planning board and village board did.
And it's reflected in the AHRB is led by an architect. The planning board is led by a civil engineer. They're professions that look at things with different sets of eyes, different sets of priorities. So the issues that the AHRB are going to look at when they look at massing is different than the concern with drainage and roadways, which a civil engineer is going to focus on more heavily than the architect, who's going to look at the similarities and dissimilarities and how you put these elements together to create a streetscape. It's, you know, two different professions.
That's exactly right.
Are there other people who would like to be heard?
Could I just respond briefly to Mr. Potential's
Sure.
comments? With respect to bulk, the site plan regulations of the village specifically talk about bulk and massing in the site plan regulations. So the planning board addressed the bulk massing. There are planners on the planning board. They addressed that issue. With respect to the comment, Mr. Monti, about experts, we have ours, we've always had ours here at these meetings. We have an architect, we have an engineer. You heard, with all due respect to Mr. Potensky, we know each other. He's a lawyer, just like me. I'm not an architect, I'm not a planner, I'm not an engineer. He's giving you an opinion. And for all these meetings, we have yet to hear from any professionals any architects, any other civil engineers refuting what we've stated before these boards. You know, it's interesting, you know, they talk about Rudy's. We talk about, and I think you, Mr. Chairman, noted that, you know, is there an expectation that nothing be built here? Well, just again, by way of history, the only reason why this view is there today is because the applicant tore that building down, requested by the village because it was deemed a public nuisance. Before that, Rudy's was there, decrepit, and there was an approved site plan for the Rudy's site that was much larger than what we are proposing. So, again, to comment on what you're saying, there is no expectation. The reason why there is a view there is because applicant created that view. So, you know, I don't want to lose the forest for the trees here, but that's really, that view, as of a few years ago, didn't exist. It was blocked, and it was going to be blocked even further had Rudy's gone and done their approved site plan that was approved. Okay. With respect to, there's a comment that Mr. Potensky made that, quote, the board took a hard look at the evidence in the record. Well, that's interesting because our position is that evidence wasn't in the record. Okay, it was sprung upon us that night at the AHRB, so we beg to differ on that statement. With respect to the numbers that Mr. Potensky exaggerated, you know, we have our experts here, and the numbers that he stated, I guess, what was it, 31%? That was in excess of 31% of the numbers that he gave. Again, it's Potensky, not an architect, not an engineer. Okay, so those numbers that he told you were 31% exaggerated, okay, from what reality is. And the other issue with respect to, we talked about excessive similarity of the development. If you look at page 3, excessive similarity of the development itself deals with the facade, okay, the facade of the structure, not two separate buildings together. It deals with the facade. So I don't know what Mr. Potensky was getting at there. Again, he's not an architect, but we presented empirical data tonight. We presented empirical data in planning board, the trustees, and AHRB. Again, the objectors here haven't presented, other than an appraisal, which we can all refute that the appraisal assumes wrongfully that that site is going to be left vacant. Okay, and there are other issues with the appraisal that I can get into, but again, people want to be heard, and I can come back to that.
Can I just ask you one question? This is sort of the same question I asked the other council, which is, how would you suggest that we think about it, to the extent anyone on the board is of the view that the proposed project, you know, is not excessively dissimilar compared to 19 Livingston Ridge. Sorry, Livingston Ridge, right, 19, right, Livingston Ridge, excuse me. But it is excessively dissimilar to the houses, you know, across the street, and how would you suggest we think about that or resolve that question?
A good point by the applicant. You know, the AHRB's determination purposely excluded Livingston Ridge in its discussion or in its calculation, which we find quite interesting since this is modeled with that look. So they excluded that from their deliberation and their decision, Livingston Ridge, which we find quite telling.
Well,
You don't wanna answer my
I don't
question?
think that answers the question.
No, but
My question is predicated on the assumption that some of us may think Livingston Ridge is relevant, but it's not the only relevant consideration. So I'm asking, you don't have to answer if you don't want to, but I'm looking for guidance on how do we think about it. It happens to be a 200-foot area that has different kinds of structures in it. There's Livingston Ridge, and then there are, you know, much smaller structures. And we're doing a comparison with both, and I'm just trying to think through how should we do that? How should we think about that? Mr. Potensky made the argument that we should weigh more heavily the homes that are more directly impacted and that are right across the street. And there's certainly some logic to that. I'm just giving you an opportunity to say what your view is.
But I think if that's the case, then you're asking us, I guess, to design a raised ranch type of structure structure. And again, I'm not an architect, but we have one here who can address it,
No,
so.
I think we're asking a legal question.
I think it's an architectural issue, though.
He doesn't want to answer. It's all right.
I'd like to address that in that we conform to the contextual design. That's, besides criteria, that criteria was developed by the village based on the context of the neighborhood to create the MDR1 zone. So anything that we do that conforms to that is, by definition, contextual to those requirements. Now, Livingston Ridge is only a few homes away, and it's a very significant portion of the streetscape. Ordinarily in zoning, there are transitional areas, and this site would be the perfect transition from single-family to this institutional, Cabrini, which is normally filled by something like a multifamily project, although this is not. This is attached homes, but the density adjacent to some sort of more intensive use is usually higher.
If I could just briefly, I think the question is a good one. What the code says is that you should look at structures within 200 feet. The intent behind the code is to look at whether or not the proposed project is excessively, let's just start with dissimilar to the surrounding structures. It's important to note here that there are two standalone multifamily homes between 19 Livingston and Livingston Ridge, namely, I think it's 29 and 33 Livingston. So when you look at the structures that are the closest, the residences that are closest to 19 Livingston, you're talking about single-family homes that are broken up. One could make the argument that Livingston Ridge is the anomaly in this zoning district, and that's why, when the village board amended the code in 2011, they zoned out these types of buildings, because it's an anomaly. The majority of the buildings in the close vicinity are single-family homes. Also, wanted to correct two quick things for the record. The appraisal reports were submitted timely to the Architectural Review Board, and we submitted stamped filed copies of those cover letters to this board, so it's in your zoning packet. And the appraisal reports did take into account the view at the time of the purchase of Mr. Brosi and Ms. Corrales' residences. So the analysis was not simply no view versus view. It was view at time of purchase versus view after this proposed project is constructed. Thank you.
Well, before you go, let me just address one other thing. I think the two homes are two multifamily homes that you addressed. They're not single-family homes in that area. So let's go back to my colleague's question about the surrounding area, which is defined as the 200 feet. That's the neighborhood. And the code is talking about a harmful impact upon the surrounding area. And you keep focusing back on two particular homes, which I understand you represent, but what do you have to show us that there's going to be a harmful impact on the overall surrounding area?
Well, so we're talking about structures within 200 feet. That's what the code looks at, whether or not there's going to be a harmful impact on structures within 200 feet. So let's talk about the homes to the north that are within 200 feet of the project along Livingston. Those properties currently have the view of the Hudson River. After this proposal, if this proposal is constructed, they would still have a view of the Hudson River, totally unobstructed by this project. Now let's look at the homes that are within 200 feet that are across the street and to the east of the proposed project. Those homes will be directly impacted by the construction at 19 Livingston if it were permitted to proceed like this. And by the way, just to reiterate, it's not that my clients oppose any and all development at 19 Livingston, it's just that they want it to be done in a respectful manner in accordance with the zoning code. We don't believe that that's what's been done here. Our position is that these two structures that are 140 feet by 7 feet by approximately 45 feet tall are just enormous and out of character with the zoning district.
I'd be happy to have both counselors respond to this question. But as I listen to the discussion so far this evening, I'm listening to two different themes. I'm listening to a theme which is architectural, which is this building similar or dissimilar? Is it contextual? And I'm listening to a theme which is more legal than architectural, and that's usually revolving around, is Livingston Ridge a precedent or an anomaly? And I guess I'm interested in your opinion on the latter. Is Livingston Ridge a precedent or an anomaly?
Is it a precedent or anomaly? Well, that's somewhat of a loaded question because that's not really what the AHRB is charged with when determining excessive dissimilarity. They have to look at all structures within 200 feet, right? So assuming that Livingston Ridge is within 200 feet, then it should be looked at just as the other properties should be looked at. But when you also look at the other criteria that the AHRB has to look at, is there a harmful effect on other properties? I would submit that there may not be as much of a harmful effect on Livingston Ridge because of where it's situated in relation to the project as there is on the homes across the street. So I hope that answers your question.
Mr. Chairman, we have a couple of folks.
I mean, it's whatever.
Annalisa,
Yeah.
Hi, Annalisa Corrales. I live at 12 Livingston Avenue. Thank you for your time tonight. On your last question of whether it's a precedent or an anomaly, if you look at all of the structures within 200 feet, the majority of those structures are either single-family or multifamily standalone residences. And Livingston Ridge as well has separation between buildings in a way that each building does not, is not similar in massing to the proposed site. I would say that when you look at the majority of the buildings within 200 feet, Livingston Ridge is an anomaly because it's the only one that is structured like it is. All of the other surrounding homes and residences are standalone. Between this proposed site and Livingston Ridge, there's one single-family home, which is 33 Livingston, and there's a multifamily home, which is 29 Livingston. So I think when you take all of that into account, you can consider Livingston Ridge an anomaly, and I think that's why the AHRB called it that in their opinion. The other thing that has been talked about a lot by the applicant tonight is that there's an expanse of view still preserved here. I beg to differ because the two buildings, which are 140 feet long each, are staggered. The back one slightly to the north, the front one slightly to the south. From the street level and from my home, you will not see the river when those two structures are stacked together, which are parallel to the street. And as has been said by the AHRB very far back, including on April 22nd, 2013, and all the way up to now, they are faced with a site that's 1.29 acres. They have all along wanted to build something that had this 882,000 cubic square feet that we talked about, but they can't seem to get it to fit onto their site. And what they are required to then do is to look at the site. They need to take the site into account, take the surrounding architecture and massing into account, and build something that suits this site. What they've done is they've taken something in the abstract that they want to be able to sell, and they've tried to, again, fit a square peg in a round hole here. And I think that's why we're seeing, as a result, excessive massing that you've so aptly pointed out. I would also, again, reiterate that the appraisal that was submitted was based on the view I had when I purchased my house in 2007, which included Rudy's Beau Rivage. I never expected I would have a completely unobstructed view because Rudy's was there when I purchased the home. I could see the river to the right and to the left. Residents who walk by there can see the river, even before it was torn down. So residents, even of Livingston Ridge, will be negatively impacted by this structure. They will no longer see that. My appraiser estimated that the value of my home could be reduced by as much as 23% after this site is put up that will essentially obstruct the entire view, including the Palisade Cliffs, not just the river. So I think that has to be taken into account, and it was by the AHRB appropriately. And the applicant did have an opportunity to go to the clerk's office and get a copy before that hearing, and even if it didn't, the applicant has it now. And I would also say that you had mentioned earlier, are there objective things that we've submitted on the issues of dissimilarity and similarity? Yes, in fact, architect Stephen Tilley also submitted a letter in the record during this, the course of the proceeding before the AHRB. He's here tonight. If you would like, any clarification on the items in his letter. But you have a lot of objective data, including the measurements. My home is 28 by 33. Their structures are each 140 by 60 by 45, and there are two of them. So I appreciate very much all of your comments tonight. Thank you. Any questions?
Please.
Donald Tagliano, 81 Grandview Avenue. I know this isn't about the view, but the applicant's attorney mentioned the view. The local waterfront revitalization committee was appointed by the village board of trustees back in 2005, and Rudy's was still standing there, and I think was even still in business. And they identified view sheds in the village of Dobbs Ferry to be preserved and saved. And this was one of those view sheds that was deemed important to save for our community in Dobbs Ferry by that committee that was appointed by the village board of trustees. So that view was there and identified by that committee to be saved. Thank you.
Please, Mr. Brody.
Good evening, my name is John Brosey. I live at 152 Broadway, if you already know, right across the street from where
Excuse
this...
me, were you in the 200-foot area? I think that's the, did you get a,
well,
Brian, is that the circumference for notice?
Yeah, 200 foot is the required dimension, and I believe Mr. Brosey is beyond that.
He's beyond that, okay.
I disagree with that. I think if I've measured from the border of the property, of the 19 Livingston property, to the border of my property, which includes the common elements of the condominium unit, because it's a condominium development, and it is within 200 feet. And in fact, although I don't have a record of anyone, and I checked with our board, receiving a notice for this meeting, we did receive one for the Architectural Review Board. So I just don't think that's accurate.
If you did for them, I would think that you would be in that radius. I mean, they don't go beyond, I don't think.
Correct, we did receive one for the AHRB. I was unable to verify. I think it came not to me directly. It went to I believe our board, and they sent it around to everyone else.
Do you know how multifamily, how condominium complexes are noticed?
If it falls into the common area, it's noticed to the homeowner association.
Yeah, and I think that's what
Okay,
happened.
so if it hits the condominium property,
It would be the
then
homeowner
the
association.
complex is noticed.
Yeah, and I believe we did receive that for the last AHRB, although I checked with our board president, and they said they didn't receive one for this meeting, but couldn't have overlooked. It's hard to say.
There were none for this meeting.
That's what I was told by the president of our homeowners association.
No, I mean, there are.
Oh, there are.
No one has gotten one for this meeting.
Okay. Fair enough.
It's just procedural, and it is the way it is.
Understood,
Yeah.
okay. So I don't want to take a lot of time because it's getting late. I just want to sort of give a perspective. I am an attorney, but I don't want to give a legal perspective here. I just want to give a perspective as just a homeowner and somebody who walks up and down that street every day. So I did buy my property when Rudy's was still there before the development group purchased the property. I knew that Rudy's was in trouble and it might be replaced with something. And so, with my real estate lawyer at the time, I took a look at the Dobbs Ferry Code and tried to understand sort of the process. And one of the things that I understood, I'm going to use this as a proxy for excessive dissimilarity, was that one of the things that would be considered was whether something would be built that's out of character with the neighborhood. And I think that's a fair layman's proxy for excessive dissimilarity. And so I understood that, and so I bought the house based partly on reliance on these kind of things. And honestly, I never in a million years could have imagined that we'd be looking at a structure like this. 6 massive units, 140 feet long. Chairman Hoffman, I think your Google is pretty good because I actually paced off the Livingston buildings. It's the beauty of the Queens measurements versus the metric system, is that I can do that. And I got 80 feet, so I think your 77 is pretty good.
Right, plus or minus.
Yeah, again,
It's
my
close
feet
enough.
aren't exactly accurate, but so you know, I think when you look at it that way, to me, we talk about objective criteria and such. I mean, we've got pictures. You basically know what the other structures are. Livingston Ridge, even if it is a precedent, each of those buildings is you know, 70, what's the math? Not, you know, these units are gonna be almost double the Livingston Ridge, even if you do use that as a precedent. And so when I walk up and down the street and I don't see any vans and stuff parked around, I think it's a beautiful street. So I think, you know, it just seems totally out of character to me. That's all I'm gonna say. It will impact the value of my home. We submitted the appraisal as well. Like most Americans, a substantial amount of my net worth is in that home. Something like this would harm me. So I respectfully ask that you uphold the HRB's decision. Thank you.
Please, sir.
My name's Steve Tilley, and I'm an architect at 22 Elm Street. And I was asked by Ms. Corrales and to write a letter with my opinion on the architectural merits of the architectural review considerations of the project. And I was paid for that service, so just for a matter of full disclosure.
I'm assuming the other architect here was paid too, so don't worry.
I would hope so. We like, you know, we do like to be paid for those services.
Excessively?
If possible.
If possible.
Right. As it happens, I was also the chair of the Architectural Review Board for 13 years, and I was the chair when the Livingston Ridge project went through its review. And then I also participated in the redrafting of the architectural review standards. So, for better or for worse, I've been embedded in this part of the world. And I have to say, one of the reasons that we changed the height definition in the zoning code was because of a set of things all around the village where we're a sloped village, and you have to deal with the fact that suddenly on the other side of the downside of the hill, you've got a thing that looms large, even though it may be one story at the top of the hill. And that's what happened with Livingston Ridge. I think to everyone's surprise, to the detriment, we didn't have the three-dimensional tools that we now have to really envision a project, which is a tool that I wish were used. I wish we had a three-dimensional model of the entire site so that everybody could evaluate the impact, and you can actually look at views, and that's what we do in other projects, and it's really important and robust tool, I think, that's now available for the analysis. I think that I wish we were at the beginning of this process and had those kinds of tools and were able to have a really good discussion with everybody, with Paul and Mr. Cardew. But I think it is true that you're, for better or for worse again, in the position of looking at the current architectural review guidelines and examining the decision that was made at the ARB. And I did go, since I had submitted a letter, I went to that meeting, and while there was, again, the council made good representations, I think it was clear that the members of the board had spent a great deal of time looking at the application. So I don't think it was, I mean, at least I heard from what they said, and I interpret that as evidence that they had looked at the facts, they'd spent time with the application, looked at the drawings, and visited the site. And so that I don't think that the application was ignored in those findings. And my own opinion is and was that given the standards that they were, that they have to operate under, that their decision was the right decision. Regardless of the previous comments that had been made. Lots of comments, as you know, were made at this board and at every board in the course of considering something. And I don't think an applicant, I mean, as an applicant myself, I really, I look for, I read the tea leaves in comments, but I'm not entitled to rely on someone's comment that, you know, I like this, you know, because it may be that, you know, I don't know, I had a really nice glass of wine before I came to the meeting. I don't, you know, it's, but it's really the decision, the thoughtful decision of the board that matters, not preliminary comments. And I mean, I think we were at pains, it certainly was, one of my concerns was to try to expedite the application process and to try to have an integrated review by the architect review board and the planning board at the same time so that you didn't have this kind of back and forth. But here we are, I think, at the, you know, at the later end of this, of the process with the facts and the standards. And so I think that even though Livingston Ridge is beyond 200 feet, and we did 200 feet, I think we were actually.
No, that's within 200 feet.
It is within, part of it is within 200 feet.
The front buildings are.
Right, okay. So.
Most of the second front building.
Right, okay.
The cutoff is somewhere at the end of that.
So I think it's still visibly from the footprint and the massing is a different animal from what's being proposed. I think the applicant, you know, will stipulate that, and I think simply that, you know, all of us looking at Google can stipulate that the proposed length of the building, which is really, you know, I think everybody's identified it as a major concern, is different from the way that Livingston Ridge addresses the street. And also, if you look at the preponderant character of the neighborhood, you know, kind of from Walnut to, you know, to back to the intersection with Broadway, it's buildings that are kind of, you know, big old rambling houses, and I think that Mr. Carey has captured some of that in the detailing of the building.
Absolutely.
But the scale is kind of, things are, you know, not lined up, things are kind of here and there. There are some garages, there is some parking that you get to from behind, you know, in Al Borelli's house and other places. So I think that's the scale. When we were looking at, in the vision plan, looking at neighborhoods, trying to identify consistent areas, we were saying, okay, what's the best part? What's the kind of overriding, and what's the part that we all feel is kind of feels good? And it's really that part of this neighborhood that was the feel-good thing that ought to be identified as the thing you're trying to match. And it was done in the architecture, but it's not, in the massing, it's not done. And so I think it's pretty straightforward. I don't think, I mean, this may play out in some other venue, but it's from the straight architectural review point of view, I think there's a case for dissimilarity, and I would think that would really ought to be the finding, and you have a solid basis for that finding.
Could I ask you a couple of two different questions?
Sure.
When you were the chair of the AHRB, and you.
It didn't have an age then.
I didn't want to bring that up. When you received a project that had a large footprint like this from the planning board, so that it was approved as a very large structure for them, what did that mean for you?
Well, it clearly, one takes that into account, and then in some cases, we would suggest that maybe there ought to be a return trip to the planning board, and if an application changes substantially, then obviously
It has to.
that process
Right.
has to happen. In other cases, we did feel like we were rearranging the deck chairs on the Titanic. In cases of, I don't think we had anything exactly comparable to this. We also had probably fewer tools available. It was the whole point of, at least some of us, when we were drafting the zoning revision, was to provide a more fulsome and a more well-articulated basis for the architectural review, and ideally integrate that into the planning process at an earlier stage.
My other question is, I thought the applicant brought up a good point, that this is a transit, this is an important site, but it is also a transitional site.
Yeah.
And how, and this project does transition. One can say the transition is too large, but
Yeah.
how
Well, I think-
would an architectural, how would you view that?
Well, I think it's right that, it's not a place for split level ranch houses, that there is a moment for a transition, but I still think the suggestion about what you're emulating, it's like some of the other houses which have become multifamily houses, or 2 or 3, which is, MDR was sort of geared to 2 and 3 family houses.
Right.
And sometimes maybe putting them together so that you have some freedom to arrange. And that would be possible on this lot, certainly, and you could do 12 units on the lot as multifamily houses. So I think that the transition, some transition in scale and, into new buildings on the property is probably right, certainly from across the street. And then there's obviously a gigantic transition, which is why it's a different zone. And the zoning was looked at to the extent that we could to try to draw lines that didn't create anomalies in a zone, that tried to say, okay, this is what we're headed to in this area, and there are always gonna be things that you just can't.
Right, you can get it 70 or 80% right. You
Yeah,
can't
right,
get
exactly.
100%.
This is not perfection.
Yeah. Thank you. Please.
Hi, my name is Klaus Whitney, and I'm a resident of Dobbs Ferry. I live in Summit Terrace. I was told by the chairman of the planning board that if I should maybe get involved more and come to more meetings, and this is one of the reasons I'm here. I'm very interested in what's happening in Dobbs Ferry. But let me just say something which I'm listening to everybody here, which I want to point out to the board. What I don't understand is, well, I do understand, and I understand now what creeping development means and what's happening here in Dobbs Ferry. When we talk tonight, benchmarks seem to be the Livingston Ridge. That all of a sudden is a benchmark where this project is being judged against, not the rest of the houses in the neighborhood. Now you're doubling, or making a massive structure. That becomes the benchmark now for the rest of the street.
So all of a sudden, now someone's come and say 500 feet, because now I'm comparing it to 19 Livingston. That's what's happening here, okay? Because we approve something which I believe is an anomaly in the street, that becomes a benchmark. And everybody points a finger and says, hey, we got this thing here. Now we can build something not a little bigger, because we got the benchmark here, we go up a little bigger than that. And this is something you have to consider also here in Dobbs Ferry, because that's what's happening here in Dobbs Ferry. They're getting all these variances, all these things, all these anomalies, and they become the benchmark. And all I see, houses are getting smaller and smaller, densities are getting less and less, footprints are getting less and less. They're getting bigger, 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 bigger. Higher floors, higher this, higher that. So I would say that this project is an anomaly in this street. And it was a residential street. Okay, the Livingston Ridge was an anomaly. And this would be a much, much bigger anomaly and becomes a new benchmark that all other projects are going to be judged on. And I think this is really what the Architectural Review Board is also saying, implicitly, maybe not explicitly like I'm saying it. Okay? We call it, you call it the excessive dissimilar, I call it character in the neighborhood. It doesn't meet the character of the neighborhood. This thing is just one long frontage to me. I mean, it is subjective, but
The AHRB called it an
okay, but I'm saying, I'm putting it in layman's terms, what somebody else used here, because again, you know, you use all these terms, we don't know all these terms, this is the way I put it in plain English. But, you know, it is subjective, but even from the pictures, if you show me a picture of a single family home, there's some sky around it and so on and so on, you can see through it, you can see the rivers. And then I see this long frontage, things attached, no, it's separate. It doesn't matter if you take something that looks similar to another house, but you're piecing together like a Lego set. And now instead of having a house, you got a huge apartment complex of what it looks like. And that's what we're talking about here tonight. So I just humbly and respectfully ask you, consider what the concern here is in Dobbs Ferry from citizens like me, who I don't live there, it doesn't obstruct my view, but it bothers me how I see creeping development moving along. That is called creeping development because we're using the wrong benchmark. Thank you.
Good evening, Neil Whitehouse, 26 Hatch Terrace, Dobbs Ferry, Mr. Chairman, members. Hatch Terrace is somewhere around here. It's off Walnut Street, between Walnut Street and Broadway. So it's outside the 200 foot criteria, but it's definitely in the neighborhood. I own a 4-family building built in 1893. It's one of the larger buildings in the neighborhood. Not the largest by any means. There is no question that Livingston Ridge is an anomaly, and that the measure of similarity and dissimilarity would be inappropriate to use that compared to all of the other buildings in the area, not just within the 200 feet, but within the neighborhood, within the, excuse me, the MDR1 area that is defined. So I urge you to uphold the decision of the AHRB to deny the application because of the dissimilar nature of the building. My property, I'm not sure what the volume is, what the size of it is. I would imagine it's, I don't know, 4,000 square feet or something. And to have something that is so massive, it has no bearing, it has no relationship, it has no character that has anything to do with this neighborhood. One other thing that I would like to offer, if I may, to Mr. Monte's question about the appraisal inquiry. I'm not a real estate appraiser. I actually appraise commercial aircraft, but I am an accepted expert in appraisal. And just to address a point in terms, well, I'm qualified in front of federal, state, and international courts, and I'm in major litigations. The technique that is used, the most common technique that is used in asset appraisals is comparables. In fact, there are free programs on the internet you can go to, put in your property location, and it will give you the comparables in the area. That's the primary thing that real estate appraisers use. So that is a standard acceptable appraisal technique. So I just thought I would add that. Thank you.
Anyone else? Mr. Schroeder?
Just a couple of comments I'm hearing that are repeated, talking about our project is massive. I mean, when you look at our project, you can look on the screen, we're smaller than Livingston Ridge. Okay? We're not even close to that massing. We're a smaller project, and that's a fact. We're not that size. With respect to Livingston Ridge, you gotta consider it as a whole. You gotta look at the neighborhood to look at excessively dissimilar. The west side of Livingston Avenue is different from the east side of it. So you have to look at these, and you can't just focus on a couple of houses and determine the character of the neighborhood or the excessive dissimilarity. You have to look at it as a whole. Our project is keeping in line with the neighborhood, okay? And again, you've heard it tonight, Mr. Carhu has captured the architectural essence of that neighborhood with respect to the homes that are there and also to Livingston Ridge. So you can't just say Livingston Ridge bad and it's just the anomaly. No, it's part of the neighborhood now. Like it or not, it is part of the neighborhood, and that's something that you have to take into account when you are considering excessively dissimilar. You know, I heard all the comments about this, about variances. I know a gentleman spoke. We don't need any variances on this project. You know, this is a result of the Dobbs Ferry Code. We built a project that is within the four corners of the zoning code. There are no variances needed. We didn't come to you for a variance. We came to you for a waiver of sky exposure plane. Denied, went back and we fixed it. You know, again, with respect to just one other point that I'd like to make on, you know, Mr. Tilley spoke tonight. It's the first time that we've heard Mr. Tilley speak in 2 years on this project. And again, going back to what I stated this evening, I understand that something was submitted, wasn't submitted to us to refute or to talk about at a public meeting.
It's in the public record.
Did you, it wasn't provided to the applicant. I mean, Mr. Batensky has provided me with letters the day before, but I never received a copy of his submission from Mr. Tilley or any other appraisal. It may have been submitted to the record, last minute. First time we hear about it is in a written decision.
Just to clarify, all of our submissions have been made to the village and stamp received, and council has had ample opportunity to get copies. I don't recall receiving any copies directly from council. We've had to go to Village Hall, submit a FOIL request, wait 2 to 6 weeks, or whatever the case may be, and get copies. So it's a little bit disingenuous to say that we haven't provided copies of everything. I think at the end of the day, the analysis this board needs to do is pretty cut and dry. The criteria for the AHRB are set forth very clearly in the code. The AHRB applied those criteria to the evidence. I don't really see any new evidence that's come before this board tonight. The applicant hasn't provided any appraisal report to refute the appraisal that we submitted. The dimensions of the buildings haven't changed since the AHRB looked at them. They are what they are, and respectfully, they're very out of character with the community and certainly the structures within 200 feet that are directly across the street. Thank you.
Anyone else? Mr. Schroeder?
Yeah, just speaking, I mean, Mr. Batensky submitted a letter which we received yesterday. There were points raised in his letter, also points, legal points, other issues raised tonight by your board that we want to present in writing at the next zoning board meeting to refute and to discuss the issues raised in Mr. Batensky's letter, again, which we just received, and also some of the issues that were raised here tonight. So we'd like that opportunity to submit that as part of the record for the next zoning board meeting.
Could we talk about which are the troublesome items that he's raised?
He's
Because
raised,
they
he
may or may
submitted a
not be
letter.
relevant to what we're.
There are legal
what we're
issues that were
deciding.
raised. I know there's been raised some issues, and legal issues. So, but it's a record. We want to present something in writing to address the 4-page letter that Mr. Batensky submitted. Again, not in a timely manner. We like to address it, and we're entitled to that right to submit a written submission to your board to address what was discussed tonight, and also to address the comments made by Mr. Batensky, his client, and the public.
I think that's fair.
Thank you.
Anybody? You know, that's,
Especially out of town.
That's,
Otherwise,
you know,
it's
well,
dead
you
less.
made, that's troublesome, because we'll have a different,
right.
panel, which we'll have to have.
Well,
Is it permissible within the context of the lawyer's purview on this board as opposed to the non-lawyer's purview on this board, for us to have a vote tonight and they could submit what they want after that vote?
I don't think so.
No.
I don't think we can do that.
Yeah.
Okay, so then you're going to get us to your point,
But
though.
I think both, the public should know that the issue that we're discussing is that one member of the board who's present tonight will not be able to be present at the next meeting. I mean, everybody's schedules are there, but
we will still,
but
we will still
we
have,
will have a,
well, we will still have a quorum.
we'll still have a quorum, so if,
The John could be here after catching up on, you know, with the video. You know, if that's, if
So you're
the
asking us to
applicant is
adjourn?
fine with that, you know, and I know I will be here.
And also,
God willing,
if
next
absent members
time.
they can also review the record as well, so depending on how the next meeting goes, but we have no problem with that. I mean, if Mr. Moss wants to review the record of tonight's proceedings, and you can vote at the next meeting, if that's what the board would like to do.
It's the applicant's burden here, and they have not submitted anything new. And I would argue that nothing in Mr. Potensky's letter raises a new legal issue that requires any additional time.
Yeah, that's right. We haven't submitted any new materials whatsoever. All we've done is cite back to old materials that were previously submitted to the HRB, which was in the record on appeal. So
But if it's
I'm not sure what new legal issues.
But if it's not important, why did you submit it?
And as I understood it, he wans to respond to certain comments that were made by the board.
Respectfully, we're entitled to that.
Of course you are.
So, I'll make my written submission as part of the record.
They've had ample opportunity for months to review the materials.
Ms. Potensky, you submitted your letter to me yesterday.
There's nothing new in that letter.
Okay, in your opinion,
It's a synopsis of.
I don't wanna have argument
Over,
between,
guys.
parties. Anybody who has comments, please address it to the board.
So,
It's your,
all done for tonight?
well, we have to make a motion to adjourn
Move
and
to
keep it
adjourn?
open.
Yeah, I think we should keep it open.
Yeah.
Don't you?
Hmm?
What do we normally do with the written submission, you know?
Yeah, no, I mean, there might have to be some
There
discussion.
might, be some discussion. I think it's fair to keep.
You can always decide to close it.
Yeah, I think.
Right.
At the beginning of the next
Yeah, I think
Right.
I'd be inclined to close it to further comments that could have just as well been made tonight. You know, only as to anything new that
We,
comes up.
I think we could request that any submissions just be addressed to new issues that were raised and narrow, not just to go over other things.
Yeah, is
That's
that,
okay
is that good?
And-
Both
and
sides?
Perhaps submission should be at least 2 weeks prior to the meeting so that the board and the opposing counsel have an opportunity to review them as well.
I would
Well, you know,
certainly-
we've got the holidays coming, you know, I think a week is fine. You know, and I think you folks have each other's email addresses. Mr. Sharetta?
I'm sorry, Mr. Jones.
Why don't we say anything new a week beforehand, and please send to Mr. Potensky, and he will send to you
By email.
by email.
A week prior to the meeting?
Yes.
Yes.
And when's the next meeting of the ZBA?
It's the second Wednesday of the month. You know, so that, I mean, the holiday's gonna mess people up,
Right.
so I don't think two weeks is reasonable. You know, but just to have,
Oh, excuse me.
have some cooperation.
I was just informed that my client's not gonna be in the state. He's got a business trip, so we would ask that the meeting be adjourned to February to allow my client to be present. Or alternatively, the board can decide the matter this evening.
You have both your clients, so one of
I
those
don't,
going
I
to
don't
be
think
here?
the procedure
No,
represents, you have to carry it to the next
You
meeting.
know, I think the applicant is, if the applicant couldn't be here,
Correct.
you know, we might have an issue, but, you know, we can't accommodate everyone's schedule. You know, I would assume that he'll be represented.
Well, respectfully, my client would like to be present himself. He made comments on the record tonight. He'd like to have the opportunity to do that at the next meeting as well. and he's unfortunately
But
unable to attend.
if the information is exchanged in advance of the meeting, that would give your client the time to review it and submit to you for submission to us, any comments he might have in writing. Because frankly, I'm not here in February, I'm out of the country, and I would like to be here for the meeting.
And I'll be gone in March, so
you know,
March isn't looking
that's
so
what
good.
happens.
Okay, thank you very much. So it'll be the second Wednesday in January, submissions 1 week prior, exchanged by email on council.
Could I just,
Can we close the?
just so that this isn't like open season, I think any submissions should be very clear as to what came up during today's meeting that you're addressing. And this isn't an opportunity to.
In fairness, so this is de novo review, correct? So it's been stated, this is de novo, so we're going to submit what we need to submit as part of this de novo review process. You can't,
But that wasn't a surprise to you, though, that this is denied.
whether it's, you know, the point is, we heard comments tonight, and the submission tonight, we have the right to respond in writing to those and have it part of the record, the de novo record. And there's no way I should be limited to those comments that I should be making. Again, it's a de novo review.
Okay, so move to close the meeting?
Close the meeting and carry the matter on the agenda.
Move to adjourn?
To adjourn?
And second.
We've adjourned.
See you in a couple of hours.
I really would come, but I'm gonna be in Atlanta. Testimony.